They were classified as freedmen, descendants of the enslaved, forced to walk the Trail of Tears alongside their enslavers. But history did not forget them, and neither did the courts. Welcome back to our channel. I'm Haas.
I'm CeCe.
Today we got a hot topic for you.
Last month, on July 23rd, 2025, the Black Creek Freedmen won a monumental case against the Muscogee Nation, also referred to as the Creek Nation, reclaiming what was promised to them over 150 years ago: full tribal citizenship. This is not just a legal victory, it is a reckoning with Native complicity in slavery, and it's a reminder that Black history is everywhere, even in the tribes that walked with us and against us.
Now let's rewind. During the 1800s, the Muscogee Nation was one of the so-called 5 civilized tribes. But civilized was coded language because it meant they adopted European customs, including slavery.
Thousands of African descendant people were enslaved by the Muscogee, Cherokee, Choctaw, Chickasaw, and Seminole families.
There were captivity practices, forms of slavery before European invasion of their homelands. But these captivity practices were quite fluid. You were not born into slavery. There was not a racial component to it. Captive people had rights. They could marry. They didn't have to be a captive or a slave all their life. With the introduction of chattel slavery, then you have some Indigenous people who decide to engage in this practice. For whether it's political reasons, economic reasons, they find it profitable and advantageous to do so.
And when the U.S. forced Native tribes west during the Trail of Tears, ironically, to take their land for the expansion of cotton, they brought their slaves with them along the Trail of Tears.
They are also taking the institution and practice and people, enslaved people, with them to Indian territory and set up the same kind of slaveholding communities, structures in place to keep chattel slavery in effect. It actually becomes even more entrenched in society. You see laws that show that if you were a citizen of either one of these nations, you had the obligation to capture self-liberated people. You were fined if you had a relationship with a Black person or someone of Black and Native descent. And so this is even more entrenched than it was before removal.
After the Civil War, the U.S. government negotiated new treaties with these tribes. And in 1866, the Muscogee Nation signed a treaty promising full citizenship to their formerly enslaved Black people, or in other words, the freedmen.
Freedmen in Native tribes were not only formerly enslaved Black individuals, but they also included people of mixed African and Native ancestry, who, despite familial and cultural ties to the tribes, were classified on the Dawes rolls as Black or freedmen due to the strict racial classifications at that time.
The proof is based on a record that was created a century ago called the Dawes rolls. The freedmen say the Dawes rolls are wrong because they were based on how you looked.
If you looked Black, they wrote freedmen. If you looked not Black, they wrote Cherokee.
Many freedmen were of mixed blood, but on the rolls they were listed with no Indian blood.
For generations, Black Muscogee freedmen and their descendants were recognized as tribal citizens. They held land, they voted, they participated in tribal life. But promises, as history often shows, are easy to break.
In the late 1970s, during a movement of tribal sovereignty and self-determination, the Muscogee Nation rewrote its constitution, excluding Black freedmen who couldn't trace their lineage to a Muscogee by blood. They introduced blood quantum laws, demanding that all tribal members prove they had a Muscogee ancestor by blood listed on the Dawes rolls. And this blood quantum policy gutted Black tribal membership, essentially erasing freedmen from their own legacy.
And so began a decades-long legal battle, a fight to prove what should never have needed proving, that they were Muscogee too. That decision expelled thousands of Black Muscogee descendants from the tribe.
But Rhonda Grayson and Jeff Kennedy, both longtime freedmen advocates and descendants of the original Muscogee citizens, never stopped fighting.
Sovereignty is fine, but sovereignty does not give you the right to discriminate against the people. And that's essentially what's happening. It's about greed and it's about racism is the core of the entire issue. That's it.
They began organizing, petitioning, and educating the public about the treaty rights of the freedmen.
For years, Grayson and Kennedy have been in a legal battle against the Muscogee Nation Citizenship Board, which admitted during the 2023 trial that its members had been advised by the Muscogee Nation's Attorney General to not process any applications from those who descended from the segregated freedmen roll.
The language of the 1866 treaty between the Muscogee Nation and the U.S. government is clear. The U.S. ordered the tribal nation to abolish slavery and to apply equal rights and citizenship to freedmen and their descendants. In the 2023 trial, District Judge Danette Mauser agreed and ruled in favor of the freedmen.
However, the Muscogee Nation Attorney General Office and Principal Chief David Hill challenged the ruling, sending it to the MCN Supreme Court. They argued tribal sovereignty gives them the right to alter citizenship requirements. Several supporters, even those within the Muscogee Nation, argued that when you choose to cherry pick what you want, you weaken the other language of the treaty and make yourself vulnerable to outside influences and attacks.
As mentioned, finally last month, the Muscogee Nation's own Supreme Court ruled in the freedmen's favor. Why?
Because treaty law is the highest law of the land, and the 1866 treaty was unambiguous. It didn't say by blood. It didn't say partial rights. It said full citizenship for freedmen and their descendants. The court found that denying citizenship based on blood quantum violated both the treaty and the Muscogee Nation's own constitution, which pledged to uphold that treaty. It guaranteed equal rights to freedmen and their descendants, period.
This victory isn't just for the Muscogee freedmen. It sets a precedence for other tribes with 1866 treaties, including the Cherokee, Choctaw, Chickasaw, and Seminole, who have similarly struggled with their freedmen communities.
Some tribes have already recognized their freedmen. For instance, in 2021, the Cherokee Nation Supreme Court removed the phrase by blood from its constitution and other tribal laws. That change formally acknowledges that the descendants of Black people once enslaved by the tribe, as well as Blacks who have Cherokee ancestry, should now have the rights to tribal citizenship.
We must say it plainly. In the 19th century, some Cherokees under the laws of the Cherokee Nation enslaved Black people. That was wrong. In 1863, slavery ended in the Cherokee Nation. In 1866, our ancestors agreed by treaty with the United States to forever grant freedmen and their descendants all the rights of Native Cherokees. That agreement was binding. It was solemn. For much of the next 150 years, Cherokee Nation denied these rights to freedmen descendants. That was wrong. We need to truly honor the promise made by our ancestors 150 years ago. We need to embrace the spirit of equality. We need to recognize that just as American society has often denied or diminished Cherokee history and our experience, Cherokee Nation has too often denied freedmen history and the freedmen experience.
Yet other tribes are still resisting. But now, the court has spoken. And this case forces tough questions. What does sovereignty mean if it's built on exclusion? And can a tribe be whole while denying parts of its own ancestry?
Black freedmen were there every step of the way. On the Trail of Tears, on the Dawes rolls, in Muscogee Creek schools, churches, and courts. We were not visitors. We were citizens. And now, the law finally reflects that truth.
It forces a conversation about what it means to belong and who gets to decide. It also complicates our ideas about race, sovereignty, and solidarity, because Black folks have been oppressed by white supremacy, but we've also been erased by indigenous gatekeeping.
Still, we are not outsiders to Native history. We were there. We survived. The Black Muscogee Creek Freedmen didn't win this case by accident. They won because they never stopped fighting, because memory is power, and because justice, though delayed, still found its way home. So the freedmen return not as guests, but as citizens.
Let this be a reminder. Black history lives in every corner of this land, even in places that tried to forget us. For a more in-depth look into the history of how racial classification system and the U.S. has affected Native and Black relations, check out our video about the one-drop rule. Don't forget to hit that subscribe button for more stories that the textbooks left behind. And click the like button and tell your friends about us. Until next time, guys, peace.